Welcome to Legal Issues in Recreation Administration. I'm Professor Kozlowski. Today we'll be looking at a rather obscure issue, but I think rather interesting and pretty important in terms of recreational injury liability, particularly in the context of federal recreation. And this involves the issue of federal flood control and whether federal flood control immunity is disappearing or evaporating, if you will. And this particular article was written for the May 2011 Law Review column, monthly column that I write for the National Recreation Park Association, Park and Recreation Magazine. I've been writing this monthly Law Review column since January of 1982. So let's take a look at this particular article. Start out with a general look that governmental liability for public recreation injuries on federal sites in fact should be the exception rather than the rule. There's very strong immunity available to the federal government in this area. It's sort of a two-barreled approach. Limited immunity is available to the federal government under an applicable recreational use statute, which provides that if you open your land for public recreation use free of charge, there's no legal duty to guard, warn, or make the premises reasonably safe. You simply have to avoid willful, wanton, or gross negligence. And most jurisdictions have some form of recreational use statute. And although they were designed for private landowners, they are applicable to the federal government, because under the Federal Tort Claims Act, as we'll see, the federal government is liable like a private individual under the law of the jurisdiction where the accident occurred. And another very strong immunity available in these cases is the discretionary function exception under the Federal Tort Claims Act. Traditionally, the federal government enjoyed absolute immunity, and this absolute immunity was abolished when the Federal Tort Claims Act was passed in the 1940s and changed from absolute immunity and allowed the government to be sued under certain circumstances. Those circumstances include the federal government will be liable henceforth for ordinary negligence like a private individual under the law of the jurisdiction where the injury occurred. However, immunity was retained under the Federal Tort Claims Act pursuant to this discretionary function exception, whereby governmental immunity is preserved when the alleged negligence involves judgment decision making, judgment grounded in social, economic, or political policy. So there's inherent tension in resource management, for example, between user safety and preserving the resource. As I mentioned, the recreational use statute provides the landowner owes no legal duty to guard, warn, or make the premises reasonably safe for public recreational use free of charge. Now, the decision that was the landmark decision in this area of federal flood control immunity, and the case is decided pursuant to this Supreme Court case, rather interesting in that, as we'll see, it established absolute immunity to the federal government under a limited set of circumstances. So it carved out an area of cases that treated certain recreational injury cases like the times prior to the Federal Tort Claims Act when there was absolute immunity. And this is the 1986 decision by the United States Supreme Court, United States versus James. In this particular case, the Supreme Court held that absolute immunity was available to the federal government under the Federal Flood Control Act for recreational injuries or deaths sustained in federal flood control projects. So unlike the state recreational use statutes where there may still be liability for willful, wanton, or gross negligence, where this federal flood control immunity applied, it was absolute. And this statute was particularly applicable to the federal dam projects managed by the U.S. Army Corps of Engineers and the Department of Defense. And many people think in terms of the provider of recreational opportunities. The federal state first agency comes to mind is the National Park Service, when in fact in terms of day users, recreational use through the various reservoirs, man-made lake sites, in fact the Army Corps of Engineers out of the Department of Defense is the largest provider of public recreational opportunities in the federal government. Now, following the James case, a whole series of cases, the lower federal courts had found the Corps of Engineers had absolute immunity under any and all liability claims generally arising out of water-related recreation. And many of these cases involve shallow water diving injuries on Corps of Engineers dam sites. And whether the federal government was potentially liable for ordinary negligence or even gross negligence, where federal flood control immunity applied, it was irrelevant, because under James, the immunity was absolute. Now, as we'll see, this was considered rather harsh immunity, at least in the opinion of Justice John Paul Stevens, and he wrote a memorandum in conjunction with a case involving such a recreational injury, the Hirsch case, and he commented on the Supreme Court's denial of a petition to review to let the immunity decision of the lower court stand. This involved a fatality on a federal dam site. And Justice Stevens noted that application of immunity under the Federal Flood Control Act by the lower federal courts, that in this Hearst decision, it was the latest, in his opinion, what he characterized as an expanding series of tragic cases. This was the Hirsch case, Hirsch versus United States in 1992, 6 years after the Supreme Court issued its James decision. And in fact left it in place when they denied the petition to review here in Hirsch. So in Hirsch, the U.S. Supreme Court denied the review petition, a writ of certiorari, to in fact limit the decision from James, and he refused to do so. And the issue in Hirsch and coming out of James was whether the Mississippi Flood Control Act of 1928, which preceded the Federal Tort Claims Act, as I mentioned, it was enacted in, I believe it was 1946. Flood Control Act of 28 provided the federal government with absolute immunity from any and all liability for personal injuries caused by its employees arising out of federal flood control projects. And at the time, under the Tennessee Valley Authority and the like, the government was expending vast amounts of money for flood control, and the concern was any and all liability for destruction. It's an old movie now, but if you've ever seen Deliverance, where they're moving entire town and damming the river and flooding it, that was the situation. The federal government's flood control projects, and as a quid pro quo in providing these infrastructures, particularly in the Southeast, the federal government wanted to be assured that there would be no liability for any losses arising out of federal flood control projects. So Stevens, saying James had taken a once obscure sentence in Section 3 of the Flood Control Act, and over time it had assumed greater and greater importance because it provided the government with a defense to claims for personal injury and death caused by not only ordinary negligence, but gross negligence and even conscious and governmental indifference to the safety of the public. That, in fact, this 86 decision by the Supreme Court, United States versus James, the Flood Control Act was outlined immunity in sweeping terms. Quoting from the Act and focusing on the word any, Supreme Court found no liability of any kind shall attach to or rest upon the United States for any damage from or by floods or floodwaters at any place. That was a quote, direct quote, from statutory language of the Federal Flood Control Act. And in Justice Stevens' opinion, that this obsolete legislative remnant from a statute enacted in 1928, he characterized it as nothing more than an engine of injustice. Stevens found, however, that it was the job of Congress, not the court, that had the primary duty to confront this question. Congress makes the laws, the court simply interprets the law. And if the law is too harsh, wrong-headed at this point, Stevens, rightfully so, said it was Congress's job to change it. And the Hearst decision in his memo was inviting them to do so, to determine whether any part of this harsh immunity doctrine should be retained or not. Congress, in fact, never did take up the invitation extended by Justice Stevens in 1992. But the Supreme Court, in a later case, not involving recreational injury, looked at federal flood control immunity and its scope and applicability and limited it somewhat. And in so doing, as we'll see, had a profound effect on prior decisions applying James, in which there was absolute immunity and the federal government no way, no how could be found liable. So the Supreme Court and Central Green, not Congress, in the Central Green case, in fact, provided more direction for federal courts in determining whether governmental action would, in fact, be immune under the Federal Flood Control Act. In Central Green, rather than just saying, is it a flood control project, and therefore any and all things associated with the Federal Flood Control Act would enjoy absolute immunity, Central Green, the Supreme Court, stated that the courts were to look to the character of the waters, not necessarily just look to whether or not it's a federal flood control project or not. So under Central Green, federal courts, the Supreme Court stated, should consider the character of the waters that caused the relevant damage and purposes behind their release. Was it indeed flood control or not? So all waters would not be considered the same, simply due to water damage in terms of a shallow water diving injury or alike. In the James case, there were recreational users on a dam project, and there was a whole tragedy of errors and omissions on the part of the federal government, wherein the recreational users were swept through the dam gates and killed, and it was clearly not only ordinary negligence but gross negligence. It was outrageous. But under the James interpretation, there was absolute immunity for any damage. It didn't matter whether there was any fault, outrageous misconduct on the part of the government. But now under Central Green, a little more specific approach that the character of the waters is to be considered in terms of the relevant damage. So following Central Green, it's no longer sufficient simply for the federal government to claim immunity under the Federal Flood Control Act because it involved water in a flood control project. As I stated, the Corps of Engineers in particular in these cases arose recreational injury cases, many times shallow water diving cases. The decisions, when reported, the opinion's rather short. I was going to read it and weep, just simply quoted James and found absolute immunity. So Central Green, although it didn't involve a recreational injury case, it looked to this absolute immunity. And lower courts had held the United States was immune from liability for flooding out of pistachio orchards simply because the water had come from a federal facility that had been maintained for irrigation and flood control purposes. The Supreme Court in Central Green held that this was an overly broad reading of flood control statute, that the lower federal courts had erred in applying James since 1986 because they had been focusing simply on whether the waters at issues were simply related to a federal flood control project. And as we'll see, the important point in Central Green is the direction that the courts were to look to the character of the waters involved. So the focus henceforth should be on the characters of the water, and as we'll see, in so doing, in terms of federal flood control immunity evaporating, applying Central Green, you would suspect that the applicability and scope of federal flood control immunity to federal recreational injury situations, which would be much more limited. Here, Central Green found that damage had occurred over a number of years, that water was leaking, if you will, outside the project and eroding adjacent private lands. And although it was entirely possible that water had come from many sources that flowed through the canal on the federal irrigation facility, although it had a flood control function, its primary function in Central Green was for irrigation, would James apply? In Central Green, the court noted, in contrast, where the injuries in Jones were caused by turbulent current generated by unwarned release of waters that swept the recreational users to their death from a reservoir after the Army Corps engineers had determined that the waters were at flood stage. And we'll see that's a key distinction, a key point. So Central Green, providing more direction in terms of the scope and applicability of absolute immunity of the federal government under the Federal Flood Control Act, found that flood control immunity henceforth should only apply where injuries occurred as a result of the release of waters from reservoirs. Key point, looking at the character of the waters, whether these waters had indeed reached flood stage. In Central Green, the court stated, to characterize every drop of water that flows through an immense project as, quote, flood water, and therefore absolutely immune under the Federal Flood Control Act. And here, this project was more for irrigation, but it also played a flood control function. It's simply because flood control is among the purposes served by the project. U.S. Supreme Court found this would unnecessarily dilute the language of the flood control statute. That it was the character of the waters that were causing the damage, not just that it was water related. So in Central Green, in contrast to the very broad terminology in James, the Supreme Court found immunity under the Flood Control Act would not apply if the water never approached flood stage. And here the terminus of the canal that had damaged the adjacent private property orchards was in fact not at flood stage, that it was indeed parched at the end of the summer. But over a long period of time, it caused the erosion and the damage to the private property. So with this language, looking forward, since many of the shallow water diving injuries that had generated a line of post-James federal court opinions had applied James in this very broad, sweeping, absolute sense, finding absolute immunity when in fact any injury was water-related in a Flood Control Act, regardless of the character of the waters. And some of these cases didn't necessarily occur because flood water, project waters were released at flood stage. In fact, the water may have indeed been down because of a drought, and submerged hazards under the water might have increased the danger to a recreational user swimming and diving on these federal recreation sites. And you would suspect many of these recreational injuries, in particular shallow water diving injuries, would occur in the summer months and not necessarily in the spring, when it's more likely that there would be a release of waters at flood stage. So reading the tea leaves after Central Green in terms of how it would limit the scope and applicability of James' case, you might suspect that it would provide more of a seasonal limitation. Now, since Central Green, there's been a few reported court decisions from federal courts interpreting and applying Federal Flood Control Act to recreational injury claims for federal flood control projects. In following these cases, it seems there are less reported cases involving these shallow water diving injuries, where in post-James, between 86 2001, as I stated, it was simply read it and weep. They would simply quote James. Any immunity means any injury. Immunity was broad, sweeping terms, absolute, that involved some sort of federal flood control project. That was the end of the inquiry. Now, following Central Green, you would suspect a little more detailed analysis. Keeping in mind, in any of these cases, the federal government defense really has sort of three bites of the apple, whereas flood control immunity was very absolute. It was more limited in its scope to these federal flood control projects. In the wider range of federal recreation injury situations, most of the cases, in fact, are decided, and the issues involve the discretionary function immunity and or immunity under an applicable state recreational use statute. So the federal flood control was more the third barrel of the approach, but it was, when applied, kind of the 600-pound gorilla. My own impression being defending cases for Corps of Engineers during the post-James time period until Central Green should have been rather straightforward in getting these cases dismissed. So what about flood stage waters? And to what extent have federal courts following Central Green looked at this and examined the character of the waters involved? The case of Finn versus United States from the Federal District Court of Oregon, decision was issued October 25th, 2001, one of the first reported cases following Central Green. We'll see to what extent the outcome of this case was influenced by the reasoning in Central Green. This particular case, plaintiff claimed there was no basis for the defendant's defense of immunity under the Federal Flood Control Act of 1928. Facts of the case: June 11, 1997, Kelly Finn drowned while swimming in a designated swimming area at LePage Park. LePage Park is located in the John Day River of the John Day Dam in Sherman County, Oregon, and it's a facility owned and operated by the United States Army Corps of Engineers. On that particular day, the Columbia River was in flood condition, which is a significant fact, as we'll see. And furthermore, John Day Dam was being actively monitored for flood control purposes. Now, the waters in the swimming area at LePage Park on June 11, 1997 had been allowed to rise during the day. As a result, conscious decision on the part of the Corps of Engineers to limit the flow of the water through the dam made the water deeper, and perhaps it was a factor in the drowning on the recreational beach. That Finn drowned in a designated swimming area at LePage Park, and the claim by plaintiff that the drowning occurred as a result of the Corps of Engineers' negligent operation and maintenance of the swimming area. But again, if flood control immunity applies, negligence is irrelevant. And in fact, the United States claimed immunity under the Flood Control Act of 1928. In response, plaintiff, however, contended there was no evidence that floodwater here contributed in any way to the death of Kelly Finn. In fact, plaintiff reiterated the claim that Kelly Finn's death came about because of the negligent operation of a recreational swimming beach and was not therefore related to the character of the water as required under Central Green or the performance of defendant's flood control function. The United States, however, argued that immunity was indeed available under the Federal Flood Control Act because the character of the water at LePage Park on the day Kelly Finn drowned was indeed floodwater. The federal government noted that John Day River at LePage Park, where Kelly Finn drowned, was in flood stage at the time, Moreover, it was being actively monitored by the Corps of Engineers on that particular day. So the death arguably rose out of one of the factors was the operation of a flood control project, floodwaters at flood stage. So the United States contended there was no question the Corps of Engineers at the time of the incident was actively manipulating the depth of the river in an effort to control flooding. So referencing Central Green, the reasoning, Federal District Court here noted that federal courts were directed by the Supreme Court in Central Green to consider the character of the waters that caused the relevant damage and the purposes behind their release. And the court said there were no facts in the record from which a court could conclude as a matter of law that indeed floodwater did not play any part in drowning. So there was no reason to eliminate, therefore, the absolute immunity defense under the Federal Flood Control Act. So as a result, Federal District Court denied plaintiffs' request for a judgment on the basis of negligence liability and the request by plaintiff that indeed the defense of federal flood control immunity should not apply here. The court found indeed, even with the limiting reasoning of Central Green, that looking at the character of the waters, it in fact did involve floodwater at flood stage at the time of the accident. Contrast, let's look at another case involving irrigation runoff waters. This is the Federal District Court case Morton versus United States from the Federal District of Arizona, and this opinion was issued October 8th, 2010. Here, contrast to Finn, the Federal District Court found the character of the water, applying the Green reasoning, causing the damage was unrelated to flood control. Just like the irrigation waters in the canal in Central Green. This particular case in Morton was a wrongful death action against the United States following Morton's drowning death in Roosevelt Lake. That she had taken an A-Cross road that was one of 3 crossings that ran through Tonto Creek. And she alleged that the U.S. Forest Service, who operated this land, had negligently failed to sign the route to an A-Cross road and to close the boat ramp gate to adequately sign or light the boat ramp area at the water's edge. And thinking it was a available creek crossing, she drove her vehicle through it and was drowned as a result. Plaintiffs claim that the negligent design of this road had led directly into the lake and that the decedent, Mary Morton, was in fact led into the Tonto Basin. Response, the United States contended it was immune under the Federal Flood Control Act of 28, as it had done in Finn and all of the post-James cases, claiming absolute immunity under the Federal Flood Control Act. The court noted, citing the operative language from the Federal Flood Control Act, that the James decision hinged on, the act provided no liability of any kind shall attach to or rest upon the United States for any damage from or by floods or floodwaters, and that's the key point. Looking at the character of the waters, is indeed floodwaters involved at any place. So we've got 3 any's in that particular quote from the statute. So the court noted that this provision under the Federal Flood Control Act bars recovery where the federal government would otherwise be liable under the Federal Tort Claims Act. As mentioned at the outset, under the Federal Tort Claims Act, indeed, the federal government is liable for ordinary negligence under the law of the jurisdiction where accident occurred, liable like a private individual, but not if this immunity would override it. So here the court looked at Central Green Company versus United States, at pivotal 2001 U.S. Supreme Court decision, which somewhat qualified the James decision of 1986. And the district court noted, as directed by the U.S. Supreme Court in Green, that it must consider the character of the waters that caused the relevant damage and the purposes behind their release. And key point in Central Green, henceforth, it was insufficient under Central Green to find governmental immunity, as the post-James decisions had made, simply because waters were in some way related to a flood control project. Here, plaintiffs contended Mary Morton's death occurred from an activity that was unrelated to federal flood control project. Contrast to Finn, where we saw Columbia River was at flood stage. It was actively being monitored by the Corps of Engineers at that time. In fact, the water's levels were allowed to rise on the project. Plaintiffs here, however, claim the character of the water in which Mary Morton drowned was not or could not be characterized as floodwater. In fact, the United States admitted the water in the lake was from an active conservation capacity tank rather than from the floodwater tank. So similar to the irrigation waters, if you will, in Central Green, an irrigation function as opposed to a flood control function. The United States here argued that Roosevelt Lake did contain floodwater, and that Roosevelt Dam was raised for, among other things, flood control while it was developed. And at the time of Mary's death, the waters were at an unusually high level. But was it indeed floodwater, looking at the character of the waters? The United States claimed, well, floodwater could have been released from the active conservation area, even though the water had never reached the exclusive flood control storage area. So was it flood water, but also flood water at flood stage, as we saw in the Finn decision? Federal District Court here found the United States had failed to present sufficient evidence to indeed support a finding that floodwaters killed Mary Morton, and therefore where flood immunity would still apply. In the opinion of the Federal District Court, there was no evidence that the lake overflowed or that Mary Morton drowned because floodwaters engulfed her car. Noting that the United States, as defendant, had admitted that the lake's waters came from the active conservation storage area, not from the flood control storage area. And noting the direction from the U.S. Supreme Court in Central Green Federal District Court stated that Central Green requires the courts to identify the cause of the damage rather than base a decision on the mere fact that a flood control project was involved. And that was sort of the very broad approach taken by the federal district courts following the James decision in 1986. Under those cases, if it simply involved water in a flood control project, absolute immunity would apply without any inquiry into the character of the waters, and that was the major change imposed, limiting perhaps the scope and applicability of federal flood control immunity in these recreational injury cases on federal sites, and why the article suggests perhaps it may be evaporating at this point. So the major purpose of the Roosevelt Dam was to store natural runoff for irrigation. And although it had flood control capacity, its major function was not flood control. And although perhaps high, the waters here suggesting, looking at the character of the waters, it involved natural runoff that would be subsequently used for conservation and irrigation, not being actively monitored, if you will, for flood control, waters at flood stage, in contrast, as we saw in the Finn decision. So as a result, the federal district court here concluded that it was highly unlikely that this case really had anything to do with the Flood Control Act, looking at the character of the waters. So as a result, the federal district court denied summary judgment in favor of the defendant, United States, which, if immunity did apply, as in these earlier post-James cases, those were all summarily dismissed based on the absolute immunity of the federal flood control project. So it was no longer sufficient to simply show that it involved a federal flood control project. Now, a little earlier case, 2008, from the Eastern District of California, for whatever reason, Cran versus United States Army Corps of Engineers fails to cite Green. In this case, although it's post-Central Green, is more representative of the post-James cases, where simply applied federal flood control immunity, as we'll see, to all project waters in a federal flood control project, regardless of the character of the waters. So this later case seems to be a little out of tune with the direction and reasoning the Supreme Court gave to the lower federal courts, Central Green. Here, the federal district court found the Corps was entitled to Section 702C, the language we cited earlier, immunity under the Federal Flood Control Act. They applied the absolute immunity based not on Central Green, but on the language in James. That reasoning that had been applied between 1986 and 2001 when Central Green was issued. And here, the federal district court found governmental immunity broadly applied simply as long as the injury resulted from the operation of a federal flood control project. And somewhat inexplicably here, the Cran court failed to even cite, let alone apply, the reasoning the Supreme Court, the requirement to consider the character of the waters enunciated in Central Green. So this case seems somewhat out of step with that. Once again, Central Green would require the lower federal courts, which the court here in Cran did not do, to consider the character of the waters that caused the relevant damage and the purposes behind their release in determining whether flood control immunity would be applicable or not. Here, Cran claimed her son, Cassan, aged 20, drowned in Lake Isabel while swimming with friends back and forth, small island about 100 yards offshore. Cran maintained that strong undercurrents, which swimmers were unaware, along with overgrown algae and unmarked underwater hazards, contributed to her son's death. Now, there might be arguments made on both sides in terms of ordinary negligence liability, landowner liability, or a defense is available under state recreational use statute or the discretionary function exception of the Federal Tort Claims Act. But we don't get there if indeed federal flood control immunity applies. That short circuits everything. Absolute immunity is available to the government. Then the strong currents, algae, underwater hazards, doesn't matter. Any was the reasoning we saw out of the James decision. So here the court noted that Congress had authorized the Corps, an agency of the U.S. Army, to construct a dam at Lake Isabella for flood control, pursuant to the Flood Control Act of 1944, later act from the 1928 Act. But once again, under the James reasoning, it would appear if it's water related in a federal flood control project, then absolute immunity would apply. The Corps here contended it continued to control the dam and gross pool of floodwaters contained in Lake Isabella. The Corps argued that, once again, the absolute immunity under Section 702C would attach, that there was a sufficient nexus or connection between flood control and Cassan's death. The Federal District Court agreed, ignoring, for whatever reason, Central Green qualification and reasoning. The court here quoted directly from the opinion of the U.S. Supreme Court, United States versus James, where the Supreme Court acknowledged it was difficult to imagine broader language in defining the scope and applicability of immunity under the Flood Control Act. And the district court, in fact, cited language from federal court opinions issued prior to Central Green. Those post-James cases I mentioned, a line of cases were rather terse, short, simply read it and weep. Any means any liability, there's immunity there. So the court here applied the old reasoning. Said if an injury results from the operation of a federal project, and it's the project's operated for flood control purposes, that government immunity is complete without any consideration as directed by Central Green to consider the character of the waters involved. Court noted it applies although the federal project has multiple purposes and not intended exclusively for flood control. So the Cran Court here cited the case Morisi from 1982 that even predates James, finding very broad and absolute immunity without any consideration of the character of the waters. Citing another case, McCarthy, so as long as the damage injury was not wholly unrelated to a congressionally authorized flood control project, a sufficient nexus exists for purposes of flood control immunity. That's from one of these earlier cases, the McCarthy versus United States case. So simply flood control project and the injury. If there's a connection, there's broad immunity under the James reasoning. But following Central Green, which is not applied here, it should be the reasoning is there has to be a sufficient nexus, not just to a flood control project, but the character of the waters that caused the damage. And indeed, are they, those characters of the waters, are they being operated, managed, and maintained as floodwaters? Waters at flood stage, as we saw in the Finn case, where the Columbia River was at flood stage at the time. So the Cran Court's interpretation, sort of reading the tea leaves of the cases issued following Central Green, we saw too that although it got different results, applied the reasoning of Green. In Finn, the character of the waters was indeed at flood stage, whereas in Morton, it was not. It was irrigation water, the character of the waters. Therefore, federal flood control immunity would not apply. Here, the Cran Court, for whatever reason, failed to look at the character of the waters and simply found a sufficient nexus as long as it's a federal flood control project. It's not wholly unrelated. That immunity would apply. And this case seems, in terms of its application of the federal flood control immunity, to be overly broad and inconsistent with Central Green. In that the Cran Court considered the entire flood control project, regardless of the characterization of the water causing the damage, as directed by Supreme Court in Central Green. Now, looking at the past as prologue to the future, although Justice Stevens invited Congress to look to this flood control immunity and perhaps amend it or modify it, and Congress failed to do so, it's unlikely that Congress, particularly in the present political climate, will take any legislative action in this area to clarify the scope and applicability of recreational immunity under the Flood Control Act. So only subsequent cases will give us any insight. And if Finn, Morton, and Cran would suggest that there's some disagreement in the few cases that have been issued, but you would suspect in these cases where federal flood control immunity is raised as a defense, plaintiff will attack it on the facts, look and require some examination of the character of the waters involved. So there's a 15-year gap between James and Central Green from 1986 to 2001. Moreover, the U.S. Supreme Court may not choose to review the applicability of Flood Control Act to Federal Tort Claims Act involving recreational injuries on core dam sites. Central Green involved a property damages to orchards case, so it's unlikely that the Supreme Court will look at this issue again unless there's vast disagreement amongst the federal district courts. I would suspect courts would follow more the approach taken by Finn and Morton, that Cran was somewhat out of step, behind the times, and not even mentioning Central Green in its decision. So despite the decision in Cran, most federal courts, in my opinion, and only time will tell, be likely to apply Central Green in these cases. So federal flood control immunity is still alive and well, but it's more limited in terms of those character of the waters. And I said they may even have a seasonal element to it when waters are indeed at flood stage, and those may not be the time of the year when recreational injuries are most likely to occur. So courts are be expected to consider the character of the waters that cause the relevant damage and the purposes behind their release, if any, in determining applicability of immunity under the Federal Flood Control Act, as we saw in the Finn case. Well, that ends our discussion of federal flood control immunity, so we'll see you next time.